Good afternoon, friends. Now, in last lecture, we had discussed the chapter called as the oral evidence. Today, we are going to discuss the chapter called as the documentary evidence, one of the very lengthy topic from the Indian Evidence Act, and of course, most important, in order to prove the case, whether it is a civil or criminal case, documentary evidence play a very vital role. Before we are going to discuss what are the provisions under the Evidence Act for the documentary evidence, firstly, we should start with the definition of evidence. And we are aware, section 3, we have discussed the term evidence, and it says the word evidence or the term evidence includes oral as well as documentary evidence, and therefore uh, all the evidence. Now, see which kind of evidence. See, it includes the oral as well as documentary evidence. So, evidence doesn't mean only the oral evidence or the documentary evidence. It's a combination. Sometimes oral evidence is required. Sometimes documentary evidence is required. Now, so far as the oral evidence is concerned, we have already discussed what is the procedure for the oral evidence. So far as section 59 and section 60 is concerned. Now, in this chapter, we are going to discuss the next aspect, that is with the documentary evidence. Now, when that statement, which is an ordinary statement, we call it the ordinary, that convert into the oral evidence or that convert into the documentary evidence. Because see, each and every document is not an evidence, or each and every statement will not become an evidence. When that become evidence, and therefore to understand the definition, we have to again go to the definition. It says the evidence which includes oral as well as documentary evidence, but which one? All the evidence. Now, this is what most important. All the evidence before the court. So, the oral evidence should be made before the court, or the documentary evidence should be produced before the court. So, all in case of the oral evidence, uh, before the court, and who? By the, it's a statement made by the witnesses. So, if it is a statement made by the any other person, then that would not become as evidence. Say, for instance, who are the witnesses? Like, let us take the example. If there is a complainant who file a complaint, then the complainant becomes the witnesses. Or if there are some the other person who are aware with the facts of the case, or they are having the personal knowledge of the case. I'm not talking about the hearsay knowledge, but I'm talking about the personal knowledge. In that case, those persons who are aware about the facts and circumstances case, they become and witnesses. Now, sometimes, suppose in murder case, in order to prove the or to come to the conclusion whether the murder has been committed with the help of any substance or by using the poison or all this aspect, in that case we have already discussed the expert person has been examined. Now, this expert will call as in witnesses, who is not interested. Experts are the witnesses of the course, and therefore it's a statement made by the witnesses, or it's a statement of documents, and combination of this statement of the witnesses or statement of the document we call as evidence. This is what section 3 says. After this, we have discussed the definition of the documents. Now, what is these documents? Several times we have discussed in the class that the term document doesn't mean that it should be every time in the paper. No, most of the students, they are an impression that it should be in paper. It should be in some precise manner or method. No, it is not at all expected by the legislature, because the definition is very simple and it is very elaborate also. Now, because they have used the word document means it's a matter, something has to matter, express or describe. Now, these are two words that has been used. We'll discuss express in the grammatical sense. We'll discuss and describe upon. Now, so therefore, I'm saying it's not only the paper. The word is used on any substance, and therefore, any substance. It's not limited to the in paper, on any substance. And see the method by means of letters, comma, and again they say the figures or marks or one or more of these combination. That is what or means. All this aspect has been there. So documents means that is any matter. So they're not expecting it should be in writing. It should be in a particular format. It should be in particular font. No, it's they say any matter, and that too on any substance. And what is most important, it should be some express or describe. It should be some it should be showing something. And what is to be most important, it's by the words, sign, or by the figures or the marks, or a combination of one or two things. And most importantly, this is not the only definition. Now the next part is most important, that is what I'm saying. Each and every document will not become an evidence unless the last part is most important. Intended to be used. Now this is the crux of the definition. Intended to be used or may be used for the purpose of the recording of the evidence. So unless that particular paper will be intended to be used in the matter, that cannot be comes under evidence. I will give the simple example. Let us take the example. Suppose uh, A agreed to sell the house to the B, and we have already discussed the Transfer Property Act, that the in case of the immovable property and the value of the property is more than 100 rupees, there are certain mandatory rules. One of the rules says the document should be registered. Secondly, if it is registered and valued more than 100 rupees, then the prescribed money has been paid, stamp duty has been paid, everything has been there. And accordingly, they have agreed between A and B. A is the owner of the house, and the B offered 10 lakh rupees price of the house. A accepted, and both of them, they have executed one document we call as agreement to sale. Section 54 that will discuss sale and agreement to sale of Transfer Property Act. Now they have executed this agreement to sale by mentioning certain terms and conditions. One of the condition is that the house price is 10 lakh rupees. At the time of agreement to sale, the purchaser, Mr. A, has paid 5 lakh rupees, while he has agreed that he will pay the rest of the 5 lakh rupees, that is the remaining amount, at the time of final execution of deed. And another condition, that the deed should be final deed, that is the sale deed, shall be executed within 1 month. Say for instance, 1st January they have executed agreement to sale, and on or before 1st of April, I'm sorry, the February, they have agreed to execute the final deed. Let us take the example. On the 1st April, I'm sorry, the February, when the A went to the house and requested him to perform his part of the contract, B says, I'm not ready. And therefore, it's a breach of contract. And as a result, see, I'm talking about the documents. And as a result, he went to the lawyer. Lawyer sent the notice for the B on behalf of A, requesting him to execute the sale deed contract, that is sale deed. Again, to the notice also, or after receiving of the notice also, B has done nothing, and therefore, as a last recourse, Mr. A filed a suit for the specific performance of the contract under the Specific Relief Act, and while paying the subsidiary relief against the Mr. B. Suit is filed. B appear and he filed written statement as per the order 8 of the CPC, which we are going to discuss in next year. He made a defense, whatever defense, that is different aspect. After the stage of filing of the evidence, that is a written statement by the B. Now the matter is for the evidence, and the basic rule, that is the 3rd chapter after we will going to discuss, that is in case of the burden of proof. The Indian Evidence Act says he who alleges, he has to prove. Now what he has alleged, Mr. A is alleging, that is the plaintiff is alleging, he is ready to perform the part of the contract. Now B come with the story that yes, there was a contract, so he has accepted the agreement, and therefore section 58 came into picture. Facts admitted need not be proved. Secondly, he has accepted that he agreed to sell the house, so this fact also he has agreed to. But the third contention which he has saying, he says the price of the house is not 10 lakh rupees but 15 lakh rupees. Now, for this purpose, I'm focusing on this. Now, this is the example which we are going to discuss for this chapter. That is the chapter number 5. We call it documentary evidence. Chapter number 6 again related to documentary evidence, and chapter number 7, that is exclusion of documentary evidence and certain presumption of the documentary evidence. The same example which we are going to discuss. Now, let us take the example that B came to defend that the price of the house is not 10 but it's a 15 lakh rupees. Now, burden of proof we have already discussed. This is the basic principle that the burden constant onus shifted. He who says something contrary, he has to prove. Now A come with the story that the 10 lakh rupees. Now let us come to so far as the document definition is concerned. Here, if the A come file a suit and he says, sir, agreement price is 10 lakh rupees, and it was written in the documents. And therefore, let us go back to the aspect we have already discussed. When oral evidence is allowed, oral evidence is allowed unless to prove the contents of documents. In short, the contents of document can be proved by submission of documents in the court of law. And therefore, what definition is saying? It is not all the documents which convert into the evidence, but those documents which are intended to be used as an evidence in the proceeding, that will be called as a documentary evidence. So here everything is written in that agreement to sell. A produce that document, and therefore by producing document and by examining himself in the court of law, by proving that yes sir, this is a document between me and me, and not only this, in the written statement he has accepted this kind of document, so it's accepted a fact, such kind of document is executed. Now the only fact and issue, that is the point of dispute between the parties, that I am saying it is a 10 lakh rupees and B is saying 15 lakh rupees. This is fact and issue. This is the issue between the party, the ultimate issue between party. What will be the price? What was the price fixed between the party? Whether it is a 10 lakh rupees or 15 lakh rupees. This is the only duty of the court to prove and deliver the judgment. Now see the provisions. Of course, when we'll discuss 1991, we'll discuss oral documentary evidence, exclude the oral evidence. Here A says, sir, I have documentary proof wherein it is written 10 lakh rupees. Whereas B came with the story, no, 10 out of 15 lakh rupees. So the contents of documents can be proved by production of documents. Otherwise, now why we are discussing this? Because of the definition of document. Otherwise, court has nothing to do. What is the price fixed by the between A and B? What is whether B has agreed to sell a house or not? But still, when the matter comes to the court, now court has to see the contents of documents, and therefore, otherwise the agreement to sell between A and B is relevant to the only A and B, nothing to do with the court or the lawyer. Now it become relevant to the court, and when it become or when it intended to be used in the court of law, that particular papers become a document. This is the simple meaning of the definition provided under the documents. Now, with this background, of course, this is one of the lengthiest chapters from the Indian Evidence Act, and most important also. There are 3 chapters so far as the documentary evidence of documents are concerned. In this particular chapter, that is the first chapter, that is chapter number 5 under the Evidence Act. We are going to discuss the aspect which called as the contents of documents. The contents of document, in which we will discuss what is meaning of primary documents, what is meaning of the secondary documents, what is how the secondary documents has to be proved in the court of law, what is the procedure, because law is saying that the original evidence has to be proved, and what is evidence? The original documents, or the best evidence is the original document rather. And if suppose sometimes if the original is lost or in some other custody of the other party, then what is to be done? Does it mean that the party is not entitled? No. And therefore we are going to discuss the concept called as the documentary evidence. Then we are going to discuss very interesting aspect in respect of the public documents, because before we will discuss in the public documents, we will discuss what is the procedure, because law expected original should be produced, but if there is no original, then secondary document may be produced. That is called as secondary evidence. What is meaning of secondary evidence? We'll first define and then we'll proceed, and then we'll discuss the concept called as public document and the private document. Section 74, which we are going to discuss. Then we will discuss the difference between public and private documents. Sometimes the short notes or the full question on this topic, and then we will discuss the certain presumptions under the law in respect of a documentary evidence. What is presumption? We have already discussed. Presumptions mean there is no need of proof. No party can prove the case. Like say one of the presumption, general presumption, natural presumption, that sun rises to the east. This is the presumption. No one can say it's a west, and he who say he has to prove that. Like 2 plus 2 is equal to 4. If someone says it's a 5, he has to prove. The onus is that. These are the presumption, and therefore this presumption we will discuss so far as the documentary evidence is concerned, and with reference to the last aspect, that is chapter number 7. from section 91 to 99, we'll discuss exclusion of the documentary evidence, that is oral evidence by the documentary evidence. How the documentary evidence will be prevail over the document, the oral evidence. And there are certain rules which we are going to discuss. So with this background, we are starting the first chapter, and very easy to understand. Subject to condition, you should link with the all the aspects. And therefore, in order to avoid the confusion between the student, we have intentionally divided this lengthy chapter into three parts, and we'll discuss in different. So the first aspect with reference to the document is that section 61. This is the basic rule of the Evidence Act, because in last lecture we had discussed that the oral evidence is allowed only to prove the contents of documents. That document is the best evidence, and that document has to be proved. That document has to be submitted in the court of law, and therefore, in short, in order to prove the contents of document itself has to prove. Now, the contents of the document can be proved by two types of documents. One is the primary evidence, and secondly, the secondary evidence. Now, what is this primary or secondary evidence? This is what we are going to discuss. So, the 61 deals with the basic rule that the contents of document deals or proved by the primary or secondary evidence, whereas 62 deals with the primary evidence. What is primary evidence? And the primary evidence means the original document, that document itself. In short, the original document itself is produced in the court of law, that is called as the primary evidence. Like just now we have discussed the example, if there is a dispute arise between A and B, the agreement to sell, original document of agreement to sell executed between A and B, that particular document is produced in the court of law, that become a primary evidence. And the section 62 deals with this aspect called as primary evidence. Apart from this, so section 62 is not restricted only to the original documents. There are certain because of the science and technology, we can get the different aspects. Say for instance, nowadays if you go to the registration office, now along with the hard copy, that is the document copy, you can get the CD or the copy on the pen drives. Now, what is meaning of this? Why I'm discussing this? Because when you start the practice, we are going to discuss in this aspect. Because parallelly, the registration office is giving you the hard copy, that is the document, and along with that, they are giving, after payment of certain fees, the CD or the material in the pen drive. The question is whether the material in that pen drive is a primary document. Answer is yes, and therefore we have to discuss the other types of the primary documents. Say for instance, the law has section 62 has given the list of the documents or the contents which is called as the primary evidence. Say for instance, where the document is executed in several parts. It is executed in several parts, then each part is the primary evidence. And we'll discuss one side. Or the document is executed in the counterpart, then the counterpart of the document is we call it the primary. Let us take the example. What is counter clause? Say you have an account in the bank, and someone issued check to you. Or let us take the example. You want to pay, you want to deposit the amount in the bank. So if you see the deposit slip of any bank, it has a two part. One part belonging to the bank, one part is belonging to you. That is we call it the counter slip. Now suppose by mentioning all the dates, account number, your name, description of the money, and to the counter slip as well as to the main slip, you have deposited the suppose 10,000 rupees to the bank, say on today, and after calculating, counting the amount, the cashier to acknowledge the receipt of money, he stamped to your slip as well as the slip belonging to the bank. That particular stamp is an acknowledgement that you have deposited particular amount. Now let us see, unfortunately for you, see, you have deposited amount, but unfortunately, intentionally or unintentionally, whatever it may be, that is irrelevant so far as this example is concerned. The cashier instead of making a entry of that amount in your account, he made an entry in others account. He waited for 3 days, and then he went to the bank. You say on certain days you have deposited the amount, but it is not reflected in your account. And to this, you show this counter slip. Bank officer not accepted, you file a suit. And in that said suit, the court asks you to produce the primary evidence. But the question is, because everything is with the bank officer, now what is to be done? That counter slip becomes the primary evidence. That is an acknowledgement. So it's not only the documents. If it is deals with several parts, then each part becomes the primary evidence. Or if there is a counterpart, that counterpart becomes the evidence. Similarly, please bear in the mind. Similarly, where the documents or number of documents are made by one uniform method, now or the process we call as, then and that method will be by printing, by lithography, or by photography. Then each copy, each photography is become a primary evidence. I will give the example. Suppose suppose Mr. A, he has written one book, and while writing his book he has written some defamatory material or topic, and tomorrow after reading this document, someone filed a complaint in a court of law stating that this is amounting to defamation. Now the other party appear and court directed the party to produce the evidence. Now see the book, while how the process, let us go to the process of printing process. Suppose if someone has written the book and the writer has ordered for 100 or 1000 copies, then it's by the printer, the operator has simply given options to 1000 copies and the print will become. So see the process, it's a uniform process by the one methods, and they have made the different copies by the printing machines. Each book become the primary evidence. So submission of this book is become primary. I'm not talking about the Xerox, I'm not talking about the scan copies, I'm talking about the production of documents. So the third aspect is that if it is made by the uniform process, either by the same in case of photography also, then it becomes the primary evidence. So all this aspect. So section 62 deals with what is meaning of the primary evidence. But if someone take the Xerox copy of the book and produce it, then that is not allowed. That become simply a Xerox copy, or may sometimes become a secondary evidence. What is that? That aspect will discuss in the while discussing section 63 and what is the procedure. Because when you have primary evidence, as of right you can file in the court of law. But if you have a secondary evidence, then it is not as of right. You have to take the permission of the court, and if the court require or court think that the original is not available, then and then only the court will allow. That is what we are going to discuss in the next section rather. So the crux of definition is that section 62 deals with the primary evidence. It defines the primary evidence, and also mention what are those documents which are called as the primary evidence, which has to be produced for the inspection of the court in the Evidence Act. Now with this, let us go to the secondary evidence. What is secondary evidence? 63. Now, if you go to the definition, it's very lengthy definition is provided secondary evidence. It says the certified copies under the provisions of law are, are the copies made from the original by mechanical process. Now, you might be confused between the earlier example and this example. Here, they say the copies made from the original. So, if suppose in a dispute you produce the original book in the court of law, that becomes the primary. But if you produce the Xerox copy of that particular book, then it comes to the secondary. So only because the word mechanical process is used, it doesn't mean that the Xerox copy included in the primary evidence. So it's a mechanical process by which themselves ensure the accuracy of the copy. So that this is most important. The first aspect, that is certified copy, we'll discuss what is meaning of certified. The copies made from or the comparing copy from the original, or the counterpart of the documents, or the oral account or contents of document. Now something, this is very interesting. Sometimes the oral account is also called as the secondary evidence. When it is allowed, that we'll discuss. Now what is the secondary evidence? This definition is the inclusive definition. Why inclusion? It says secondary evidence include all these things. And firstly, they say certified copy. What is this certified copy? And how can this will be used? See, certified copy means a copy issued by the authority having their seal and signature, and that can be used as in secondary evidence, not on primary evidence. Let us take the example. Suppose, see, when you start the practice, you can come across such kind of things. Suppose you issued the public notice in a newspaper, which are mandatory under certain law, stating that uh, you are the owner of the property, and you heard that some of the people they are illegally going to transfer the property behind the bank, and therefore, in order to avoid the further litigation, you are giving the public notice at large that don't purchase this property. We don't want to sell the property. Some other person who don't have authority, they are going to misuse. They are going to do misuse, and therefore, in order to avoid the further litigation, we are issued the public notice. Say, for instance, you are issued the public notice in the year 2010. Now we are 2020. Somehow, or say, let us go to example 2019, you have issued the public notice, but unfortunately you have not kept the uh, paper in which that public notice is published. You have not kept the paper with you. So after some time, without your knowledge, Mr. B has transferred the property illegally, that too. And the moment you get the knowledge, you have filed a suit for cancellation by agreement. One of your defense that, sir, before 1 year we have issued the public notice, but the problem with you that you don't have original paper. Then what you have done? You have issued the documents. Then you approach to the particular paper office and you ask the paper that on certain day you have issued the public notice. You want a copy. Unfortunately, they don't have the original copy, but they have record, and they take the Xerox copy, and on the Xerox copy they fix their seal and stating that this is a certified copy, and this notice has been issued in our public notice. This is called a certified copy. Or sometimes you will get the copy from the court of law of the order pass. That is called as the certified copy. Now we'll come to back to the secondary evidence. Uh, See, secondary evidence is an exception to the general rule. General rule says best evidence has to be produced in the court of law, and best evidence is the original document. However, sometimes original evidence is not available, or it is available to some other custody of the other party, or it is lost or destroyed. That doesn't mean that the secondary evidence are not allowed. Secondary evidence, what is meaning of secondary evidence? 62 defines it. What is meaning of secondary evidence? Law says it is allowed subject to the procedure provided. What is the procedure that we are going to discuss? So, in short, uh, in absence of the primary evidence, in absence of the original evidence, in absence of the best evidence, in certain circumstances, under this section 63, law is allowed to produce the party to secondary evidence. There are several case laws. There are several aspects under the secondary evidence, which I have mentioned in my notes. So if you go through that, then you realize that what is the importance of secondary evidence. Now, after this, let us go to the proof of primary evidence uh, and the basic rule. Section 64 deals with the proof of the documents by primary evidence. How to prove the contents of documentary evidence? One of the methods is that document must be proved by the primary evidence. This is the rule, and sometimes this is the title of the question. Examiner may simply say or simply ask you, explain. What is the question? A document must be proved by the primary evidence. Explain. Primary evidence means the original has to be provided, and this is what the provisions under section 64. It says written documents can only be proved by the instrument itself, and therefore oral evidence is not allowed, or unless the secondary evidence can be given under the provisions of section 65. So the basic rule says, so far as the written documents are concerned, it has to be proved by the primary evidence unless it is allowed under section 65, the secondary evidence. So we have discussed the basic rule 61. We have defined what is meaning of primary evidence, what is meaning of secondary evidence. We have discussed how to prove the document. It says the by the primary evidence, that is by producing the primary document. Now let us discuss under what circumstances secondary evidence is allowed in the case. Now section 65 deals with this aspect, that when court will allow to give the secondary evidence, and it's a very simple rule. See, uh, there are certain circumstances that the section 65 itself is provided the remedy for which. Let us take the what are the circumstances. Now, the first rule says when secondary evidence is allowed. The first rule says when the original document is in possession of opposite party against whom you are claiming the relief, and after the due diligence also, the opposite party is not producing the original documents, he is not handing over the original documents in the court of law, then as of right, you can produce the secondary evidence. Now let us take the example. What is this happen? See, in next year we are going to discuss the civil procedure code. Now, under the civil procedure code, we'll continue the same example which you are just now discussed. There is an agreement between A and B, and in agreement, or that is agreement to sell, the terms and conditions are there. Now B is not ready, A file a suit. The earlier section 64 says best evidence has to produce. But the problem of our plaintiff is that is the person who filed a suit, that the original is in the custody of the B. Now what is to be done? Now as a lawyer, when you start the practice, the procedure is followed in the CPC. When the document is in custody of other person or opposite side, what is to be done? And the provisions are very simple. Under CPC, there is a provision called as notice to produce. And of course, we will discuss under this aspect also. Now, what is this notice to produce? If you rely upon the documents and documents are in the custody of the other parties, then you can do one thing. You can issue the notice to the opposite party, requesting the opposite party that I have filed a suit, you are aware, and my suit is based upon all these documents, and I want this document to prove in the court of law. Kindly submit all these documents in the court of law. Now, after receiving of the notice, the plaintiff can submit the RPD receipt in the court of law to show the court that yes, sir, I have issued the notice. But even after the notice has been served, if the other party in whose custody document is, if he is not producing the documents, then as of right, the party has a right to produce a secondary evidence. So this is the first aspect. When after giving the notice also, if the documents is in other party's custody, they are not producing document, then secondary evidence, that is the certified copy, is allowed. I'm saying certified copy, not a Xerox. Then the Mr. Plaintiff can go to the registration office. He may apply to the registrar, and the registrar will issue him the certified copy. So this is the first condition, that the document certified copy is allowed. Or sometimes sometimes it happens that the custody of document is with such a person that he is not legally bound to produce the document in the court of law. Like they are we call it the privileged persons, to whom we can't call to produce the court of law. They are privileged person. No court can ask them to produce certain documents. In such circumstances, production of secondary evidence or submission of certain secondary evidence is allowed, and this is what the subclause A of section 65 provides. Secondly, even though original is there, and as I have already told, that if the other party admitted the execution of document and you don't have original, in such case filing a secondary document is allowed. Now, what is this concept? And therefore, it says facts admitted need not be proved. One of the aspects will say, see, we discuss in the same example that A files suit, B file his written statement. That is called as answer to the suit. In that written statement, he has accepted that yes, this document has been executed. Document number so and so has been executed on so and so day. So this is admission on the part of the defendant. In certain case, even though original is with the defendant, he is not ready to produce the document. In such a case, under section 65 of clause B, that the defendant, that is the plaintiff, is allowed to prove or to file the secondary evidence in the court of law. So this is something uh, beyond the control of the plaintiff. Thirdly, if the original has been destroyed, that is destroyed, lost, or the contents of the document in such a condition it cannot be read. Sometimes it happens because it's a document, and or or after the due diligence of the party also, the party is not able to produce the document in the court of law, then the court can allow to prove the secondary evidence. Now, what are the secondary evidence? Let us take the example. Now, the original is with the plaintiff, but unfortunately, while taking the document from the office to the his house, his bag is lost, and accordingly he lost the FIR. And on the basis of such document, he filed the complaint. I'm sorry, the suit. And when court asks him to produce the document, he says, "Sir, it is lost. Long back, I have lost the FIR. This is the copy of FIR. Kindly allow me to submit the document." That is the second evidence. In such circumstances, that the court can allow the production of the secondary evidence. Now, next aspect, that is when secondary is allowed. When the original of such document is such a nature that it cannot be easily movable. Uh, it cannot be directly taken to the court of law. In such circumstances, filing of secondary evidence is allowed. I will give the simple example. It's not easily movable. Say, for instance, again, refresh your memory when discuss what is the meaning of documents. It says on any substance by any marks, figures, or combination of all these. Okay, so it is not only paper. Let us take the example. You are going by your bike in a small road, and you want to go to the other side of the that particular small lane, and you use the shortcut. But unfortunately for you, the police has affixed their one board with the iron rod, and they are simply mentioning the sign, that arrow and X. That means, and they have not used the word nothing. Nothing is written, but the sign is there, arrow and X. It means no entry. It means no entry. So therefore, the definition of word, see the document says it's either sign or word or a combination. It's not required word and sign also. And unfortunately, even after watching the sign also, you enter into lane, and as happen always, to the other side there is a police officer. He caught you, and he asked you to pay the amount. You are refused, and therefore he filed a complaint against you in the court of law under the Motor Vehicle Acts. Now the provisions of the Motor Vehicle Acts are very strict nowadays, and now the proceeding is going on, and the police officer filed the complaint. Now the question in this case, you take the defense, sir, there was no such kind of board, no entry board is there. Now the question is how to produce that documents in the court of law, because it is not easily movable. The police officer is very smart. He is also student of law. What he has done, he take the photograph copy of that particular board, and he take the receipt also and submit in the court of law. This is called as the secondary evidence. In such circumstances, the photocopy of that particular rod is will be used as a secondary evidence, which is permissible in the eyes of law, can be proved when the document is not easily movable. Next aspect of the secondary evidence is that when the document is a public document, or it is a public document as defined under section 74 of the Indian Evidence Act, then in such circumstances the certified copy of that document is allowed. Okay, say for instance, you are aware with the 712 extract. 712 extract is a certified copy. It's not an original. It's a certified copy issued by the Talati. And in such if it is a public document, public means the government or the public document, then certified copy will be allowed as the secondary evidence in the court of law. So, and lastly, when the original consists of numerous of documents, then the other document showing the secondary aspect that can be used, that can be allowed, that can be produced as a secondary evidence. So in all these circumstances under section 65, the contents of documents, as an exception, contents of documents can be proved by the secondary rule. So section 65 is an exception to the general rule, and sometimes therefore the question that section 65 is an exception to the general rule of the Evidence Act. Explain. To this, you have to write all this aspect, and there are several case laws provided under section 65, which will get the while dealing the notes. But as I have already told you, the production of the secondary evidence is not uh, allowed by the court as of right. There is a procedure provided under section 65. The procedure is that whenever you don't have the original, then you have to make an application to the court of law. That is, you have to take the permission from the court of law. Court can ask or call the say from the other party what do you want to the other party, and then after hearing the court, if the court come to the conclusion that your case is fit under section 65, then court will allow to produce the secondary evidence, and later on court will exhibit means the court will number it, and court can read the contents of document, and and then the contents will be read by the court. This is what the procedure is provided under the evidence act, so far as the secondary evidence of content documents are concerned. Now under section 65, what is most important, the party is required to produce that is issue the notice to the other party. If there is no notice to the other party, court cannot directly without calling the say of other party, cannot directly take the secondary evidence on the record. Otherwise, the opposite party will file appeal against that, and this will be the ground for setting aside the order also. So you have to take care of all these aspects when you enter into practice. Now, apart from this, we are going to discuss very interesting aspect, because nowadays we are staying in such an era. Let us take the example, this example itself. Now we are taking the online lectures. So what I'm trying to show all of you, that instead of orthodox methods of evidence, now it is a we are staying in such an area that everything is in electronic forms. Now the question is how to prove, how to submit the electronic methods, how to prove it. Let us take the example, and it happened, and you realize that now it goes to the root of the society. It goes to the root of the society. I will simply give the example how the electronic evidence is most important. Say for instance, after the completion of your 3 years or 5 years course, you started practice. You're sitting in the office, and one unknown person came to you. We call as the client, and he says, "Sir, I want to file a complaint." You say, "What happened?" And he narrated all these things. The crux of the matter is that, "Sir, there is Mr. B is staying next to the me, and on the small son account, he always fight with me. There are several times there was a complaint, several times there was a fight between us. Yesterday, he started quarrel with me. He has used some abusing words. Not only this, he tried to attack me, and he tried to attack me with the help of the dangerous or deadly weapons like knife or some other sword and all these things. So I want to file a complaint." Now the question is, now this illiterate person, uneducated person, he says, "Sir, we have a proof with us." You ask, he says, or you ask him, "What is the proof?" He says, "Sir, my son has recorded all these incidents in his mobile phone. Can we use this?" Now the question is, whether this particular mobile recording will be used as an evidence, because up to now what we have discussed, the paper, the document, production, photographing, etc. And considering all this aspect, considering the future problem, the legislature has carried out the amendment due to the Information Technology Act 2001 by inserting two provisions under the Evidence Act, that is with reference to section 65A and 65B. Now what is this? Section 65A deals with the special provision for production of electronic records, and section 65B deals with the admissibility of the electronic records. Now what is this admissibility? See, just now we discussed that the nowadays the register office can be issued the CD or pen drive along with the document also. Tomorrow if something is happen, you can directly produce the pen drives. Now again in pen drive or the CD, the question is to what we call as the primary evidence. Okay. Now let us take the earlier example. That gentleman said, sir, I have a record and we have a recording in mobile phone. Can we use it? Yes, under section 65 and 60 A and B you can use it. And if you produce the mobile to the court, that is the primary evidence. But you go to the home, you take the recording from the that mobile, make a copy in your desktop, and then make a CD, whether it is a primary evidence. Now we are dealing with this era. Now we are not going to the orthodox method. We are going to this era. What do you call as primary evidence? Let us take the example. Mr. A sent the mail to the B by using some abusing word. Now B come to you. I'm sorry. A come to you. B come to you. He says, sir, I want to file a complaint for defamation, and he sent me some WhatsApp message or mail. Which evidence will we produce? That computer, that hard disk, or you can take the printout from the email address and then send to the court of law. And if you send the print from the court of law, does it mean that it's a primary evidence or to what we call as secondary evidence? And my dear friend, even though amendment is carried out in the year 2001, we are in 2020. Last year, in the month of November, the Supreme Court of India, 5 judges bench, deciding the same issue regarding 65B. The question is, because the provision is provided in section 65B, whenever you are producing the electronic evidence in the court of law, you have to produce one certificate attached to the evidence stating that, yes, this particular instrument I am using and I have made the copy from this, I am the only author of these documents or that particular instrument or computer, and I have carried out its contents are true and correct. This kinds of declaration, one kind of declaration or certificate you have to attach to this that particular document, which is not available in the orthodox method of documents. Now this issue was challenged before the Supreme Court, and there are several judgments of the High Court also, whether this certificate is required or not. There are thousands of cases, and ultimately matter referred to the 5 judges bench, and Supreme Court of India says no certificate is required, because what is the important certificate? It's just an affirmation made by the person. What is the evidential value? It's a zero, because if you go to the opening lectures of Evidence Act, it says affidavit will not be considered as an evidence. Its statement has to be made by the parties, and therefore, now the 65B, the now present position is after 20 years, 19 years rather, the position is now the Supreme Court says certificate is not required. It can be proved either in the primary or secondary evidence. If it is directly produced, see, mobile is produced, it's a primary. If there's a copy has been taken, then the secondary evidence. Same formula has been used as provided into the orthodox documents which are there. So you will in notes you will get the judicial controversy, how the Supreme Court and various high courts have discussed the including the Anwar's case or the Prafulla Desai's case rather, very landmark judgments have been delivered by the Supreme Court on the ground of electronic evidence. But let me tell you one thing. Uh, Being a student of law, I always realize it will take some times to clear all this ambiguity in the judicial decisions. What we call the judicial, because now electronic gadgets and every aspect of electronic methods, it become part and parcel of our life, and there is no excuse, and we have to cure all this problem as early as possible, so as to uniformity in the judgment. And we hope that this will be cured very soon, and we'll get the exact guidelines so far as the formation of the electronic records also. Now come to the next sub part of this topic, that is with reference to the modes of the proof of execution of documents. I'm using the word of execution of document because whatever we have discussed is the mode of proof of contents. Now we are discussing the mode of proof of execution of documents, right from section 67 to the section 73. We are going to discuss. So this is second subchapter under this chapter. That is the modes of proof of execution. Now once the document is executed means it is registered. Like transfer of property, it says that if the value of the property is more than 100 rupees, then compulsory it is to be registered. The stamp duty has to be paid, and now the document has been registered. Let us take the same example between A and B. They are registered documents. Now B is not accepting the signature. That is what the document we are going to discuss here. Now he is saying, I am not accepting the signature or the handwriting in the documents. Now how to prove the documents? And therefore, the provisions are made under section 67. If the proof of signature and the handwriting is alleged to be proved, then then it can be proved by the method of proving the documents. That is the handwriting expert also. We already discussed. Suppose someone deny that this is not my handwriting, then the opinion of handwriting can be called, or the extraordinary power is with the court. That court can compare the handwriting of the person on the documents or handwriting made by the person on the document produced in the court of law. In that case, the court will become the expert witness in such circumstances. Or if he, because we already discussed, who is the handwriting expert? The person who is acquainted with the handwriting of a person. The court may examine some other person also who is acquainted with the handwriting, and the contents can be proved. Same in case of the electronic signatures, that the certificate, when there is electronic signature is there, the authority will be issued one certificate stating that this is your electronic digital signature. Then that certificate will be the conclusive proof, rather, to prove the signature, that is digital signature of the law. Similarly, if suppose some party says, sir, I have not executed certain kind of documents, this document is not signed by me, you will prove how this document is signed by me. Then law of registration act it's provided that certain documents has to be proved in presence of witnesses. Now let us take the example in earlier case we have discussed. There is a document executed between A and B. Now B is saying that signature on the document is not mine signature. I never went to the registration office. Contents are not known to the me. Now, in order to prove the contents, because other party is not accepting, the party, that is the plaintiff, he call the two attesting witnesses, those who are present at the time of execution document. And those two attesting witnesses, they have been examined by the court of law, and they say yes, in presence of us, Mr. B has signed the documents. We are there, and he has accepted, and he has signed the signature. So, what I'm trying to show, the the execution of document can be proved by the signature, by admission of the party, or just now we discussed as per section 68, by examining the attesting witnesses uh, who are present in the at the time of execution of document. Or sometimes if there is no direct attesting witnesses available, then the same can be proved by the examining the other kinds of uh, other method for the proving of documents also. Like let us take the sometimes the the conduct of the parties play most important role. Say for instance, uh, A agreed to B sell his house, the same example which we're going to discuss. Now there is no registered document. For the sake of convenience, we'll understand. There is no registered document between A and B. Uh, on unregistered document, notarized document, which is not otherwise having the value in the eyes of law, because where law says beyond 100 rupees registration is required. Therefore, I'm saying having no value. It can be used in the evidence, but in the eyes of law, having no value. That's I'm using. Using of evidence is different, and having no value in the evidence is that is totally different. Now they have executed notarized document. On that notarized document, A has paid 5 lakh rupees. Rest of the 5 lakh rupees agreed to pay at the time sale deed. Now B is not ready. A file a suit on the basis of unregistered document. There is a bar under section 17 of the Registration Act also. Same in case of transfer of property, but there is no bar to file a suit. He filed a suit for a specific purpose. B appears, and just now we're discussing. He said, "Sir, the signature on document is not my signature." Next step taken by the plaintiff, he called the two attesting witnesses. They also deny section 71 or 70 also. Then what is to be done? You will see here the conduct of the party play vital role. Now Mr. A says, "Sir, forget about the documents. At the time of the notarized document, what B has done, he has handed over me the possession of the house, and now I'm staying in that house which he has agreed to sell me." See the conduct of the parties, and therefore sometimes conduct of the party become the proof to show the to prove the contents of the documents. In that case, court can see the probability, because see, in a civil cases and in criminal cases there are two different rules. In criminal cases, guilt of the accused person can be proved beyond reasonable doubt. In civil cases, there is no required to prove the case beyond reasonable doubt. Only uh, preponderance of probability is required. Now, what is this preponderance of probability? Here under CPC, that is civil cases, ifs and buts are allowed, which is not allowed in criminal law. Ifs and buts is allowed, or court can take the assumption also. Why? Like in case if the other party is saying this document is not executed, court can say if he is denying, then why he is handing the possession to the Mr. A? This is probability. This is preponderant probability. In that case, court can come to the conclusion that yes, generally the person hand over the possession after having certain execution of certain document. So all these aspects has to be considered by the court of law, by by uh, by the court. Under section 74 also, court has a I'm sorry, court section 73 also, the court has a power to compare the handwriting or signature of the person. In such circumstances, the court can become the expert, or in case of digital signature, court may call some expert person, or court may compare himself the digital signature. So this is all about the modes of the proving of the document. Now we'll proceed with the further sub chapter from the same topic, and sometimes very favorite short notes, that is with reference to the public documents. And you realize it's a very again simple topic from the 74 to section 80, 79 rather. Section 74 defines what is the meaning of public documents, and again it's the illustrative definition is provided. They simply say public documents. The following documents are called as the public documents, and they are giving the list 1, 2, 3, 4. One of the document, that document forming part of the record of the act. That is what the act passed by the legislature, whether it is state or the central government. That will be called as the public document, or the 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 activities of the sovereign, that is the sovereign of the state, or the official bodies of the or the tribunal, that is the record of the uh, tribunal, or the order passed by the public officer, or by the legislatures, judiciary, or by the executives, or any of part of in India, or by the commonwealth of the foreign country. and the public record kept in the state or the private documents. Now, all this aspect comes under the definition called as the public document. So, in short, the section 74 define the public document which is prepared by the public servant while discharging his official duty. Now, and that too with the four corners of his official duty. Now, it has to be made by the public servant while performing his official duty, and that too within the four corners of his official duty. Let us take the example. Suppose nowadays, due to this corona, in fact, we are aware that the state government has delegated his power to the collectors or the divisional commissioner. Let us take what is this meaning of public order, or when it become the public document. Tomorrow, if suppose the divisional commissioner of Pune order that the particular area of the Pune district will be restricted area for next 3 days, that is the curfew has been executed, ordered by the divisional commissioner, and the order is passed by the divisional commissioner with his sign. I say after this order, exactly after 2 minutes, the same commissioner he has written his letter to his wife stating that I don't want the tiffin today, and sign and hand over with his, say, the tune. Same person. Does it mean that the second sheet become the documents? The answer is no. The simple meaning is that it should be public document. It should be performed while performing the official duty, and that too with the four corners of office. Only because it is written by the public officer, that doesn't mean that every writing of the public officer become the public documents. It should be in this particular criteria, and therefore it should be for the official duty. That too with the four corners of his office, performing his official duty, and the therefore, say for instance the revenue record also, 712 extract, 8A extract of the village, all this aspect, or the certified copies of the power of attorney which is registered with the government officer, that document become the public document. Compared to or opposite to this, there is another kinds of document we call as the public, that is the private document. Section 75 deals with this aspect called as private documents, and you will be surprised to know the definition. The definition says any other documents except the documents mentioned in the section 74 are called as the private documents. In short, those documents which are not a public document become the private documents. So, section 75 defines only this aspect. Therefore, we should know the difference between the, sometimes examiner may ask you the difference between public documents and the private document. The first and foremost difference between the public and private document is that public document is prepared by the public servant, and that too while performing or discharging his official duty. Whereas private documents are prepared, those documents are not which are prepared by the person who is not a public servant. Okay, and secondly, that public documents are available for inspection to the public at large. In case of private document, it's a choice of the party. They may say no, they may deny. We have already discussed. Secondly, I'm sorry. Thirdly, the secondary copy of the public document is admissible in judicial proceeding. However, in case of private document, it can be admissible, but for that purpose, the provision under section 66, that is notice to be produced, permission from the court, all the aspect has to be followed by the parties, and therefore, it is always said the public document can be proved by secondary evidence, but the private documents, this is another difference. So, for the private documents is concerned, it has to be proved by the primary evidence also. Then, in case of, lastly, most importantly, in case of the public documents, the certified copy of the public document is good evidence where or it can be presumed to be genuine. However, in case of private documents, there is no such kind of presumption available in case of private document, and the party has to prove how the genuineness of the private documents. Similarly, so far as the next section 77 and 78 deals with the procedure how to prove the public document on the record. There are certain rules and guidelines are provided. So far as the order of, and the notification of the central government or the state government or the representative of the central government or the crowns are concerned, then the record of that particular department or the certified copy from the documents will be the conclusive proof or the documents or the primary evidence in this case. Similarly, in case of the proceeding of legislature, the parliament proceedings, all this aspect, then the proceeding is in the journal. So that journal will be the certified copy or the evidence in the in case of good evidence in the law. So in case of the proclamation or order or publication in official gazette, that particular order published in gazette, that will be used in the court of law. Same in case of the municipal corporation or local authority, the certified copies of the proceeding or certified copies of the authority will be used as an evidence so far as the public documents are concerned. So in short, this is very favorite aspect of the examiner, favorite short notes of the examiner of the public documents.